The first matter to come before the court this morning is Daryl Dorsey versus Renita Henry. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve time for rebuttal, if you let me know when you get started, I'm keeping the clock. Please don't use the names of any minors or victims, as we are posting this on court's YouTube channel and we are streaming it live. We have read the briefs and we are ready to proceed when you are.
Good morning, Your Honors. May it please the court, counsel. I am Tom Lepp here representing the appellant in this case. If I could, please reserve 5 minutes for rebuttal.
Certainly.
Thank you very much. I'll be fairly brief here. I think the briefs are very well written by both sides. I think we've done a good job of putting together what the real issues are here. Trying to cut to the chase here, though. If you take a look at the statutory scheme of RC 3119, it clearly states when you look at 964B that this statutory scheme does not limit a person seeking to recover support paid. It states very clearly that that is still something that can be done. It does not limit the remedies you have available. Here, this case, we're talking about, I understand what the appellee is arguing, the appellee's arguments. The appellee is arguing, number one, that my client chose to go to the domestic relations court first, so that should have been completed before anything else be done. Number two, the appellee has argued that there is no claim here because everything is related to the domestic relations order. I understand the relationship to the domestic relations order. However, right now, the way the decision was made, there is now a carve-out in Ohio law, and that carve-out is very clear. One cannot commit fraud against someone for fear of possibly getting hit for compensatory and punitive damages and legal fees, unless that person who chooses to do so is a pregnant mother or a mother or the mother who eventually has a child. So what we have here is this. We have that if this decision is left to stand, mother in this case, and mothers in any case, are permitted to lie if they know who the true father of their child is, with complete impunity, that they don't have to do anything. They don't have any risk of punitive damages. They don't have any risk of having to pay any court costs or any risk of having to pay any legal fees. Obviously, that is not what the Ohio that is not provided for in any of the case law that is out there, and more importantly, is not provided for in the state statutes. The state of Ohio does not have a scheme that provides for that mothers can lie about who the father of the child is. Now, looking at there are other issues here, and I understand, and my client understands that he can bring suit against the real father for any monies that my client has paid, but he can't because mother refuses to tell who that is. Mother says that it is still my client. It has been proven physically impossible for it to be my client.
Counsel, regarding the issue, regarding that issue of suing whoever the father is, if known, isn't there some case law that says that you cannot do that because the support is payable to the child?
Well, I was going to say we have other issues here of that too. There is statutory that provides that you can go back at somebody for the actual go after the person who has who is actually reimbursement for the person who should have been paying. But in this instance, we don't have that option anyway, and none of this means anything because she refuses to give up that information. So we are stuck with her. Mother has chosen to not tell the truth. She did not tell the truth during her pregnancy. She did not tell her truth after the pregnancy when my client agreed that he was the father, because she misled him into believing that he was the father, misled him into believing that there was no one else possible who could be the father. She always knew, first of all. Our belief is, this was a civil rule 12 dismissal. So accepting what we say is true, she always knew that there was possibly someone else. and she always knew that it was not my client. And we now know with the DNA testing that it is not my client. So we actually have proof of that fact. So now we're looking at, did she intend to commit fraud, or was there some sort of a mistake? The mistake would be something she would put on defense.
Let me ask you, would you be able to receive punitive damages for that conduct in domestic relations court?
No.
But sanctions would be allowable if it was contempt, correct?
If the court were to find such, yes.
And what's the status of the original DR proceeding? Was it completed and closed subject to some ongoing jurisdiction, but is it ongoing, or prior to you filing something in DR court relative to this matter, was it closed?
It was closed, Your Honor. To let you know an update, since the time of filing this appeal, there has been a 60B motion now filed in the domestic relations court, which is presently pending.
Thank you.
But that's purely to cover the bases, because we don't know what this court is going to do, and we do know what the general division did previously. Okay, that's all I have. Thank you.
Thank you, counsel.
Thank you.
Mr. Agarwal.
Thank you, Your Honor. May it please the court, Attorney Neil Agarwal on behalf of the appellee, Renita Henry Knox. Your Honor, I want to address very quickly or the appellant's second assignment of error first, where he argued the trial court violated the appellant's due process and equal protection rights under the Ohio and U.S. constitutions. I would argue that is not properly before this court. It was never raised before the trial court. It was never briefed. There was never a request for a filing on that. He never argued it. There was never a ruling from the trial court, and it's being raised for the first time here on appeal without any briefing or decision or in any way indication that it was ever raised before the trial court. So I would argue procedurally, the second assignment of error is not before this court. As far as the first assignment of error, Your Honor, Mr. Lopp keeps talking about there was fraud, and that if the court upholds the trial court, the trial court's ruling, there is no remedy. One, that is not accurate. The trial court did not say that there's no remedy. They're just saying this case is going on right now in DR court. And in fact, the trial judge said that he is filing here when there's issues currently pending. And I cite that in my brief, where the trial court said at the time he filed his case at the general division, there was already litigation currently pending in the DR court. So the appellant is trying to have his cake and eat it too. He's trying to go forward at the general division and at the DR court simultaneously. And under the jurisdictional priority rule, he cannot do that. He has to pick one lane, and he picked the DR court first. He has to wait till that is concluded. Then
Counsel, what was currently pending in the DR court when he filed the action in the Court of Common Pleas division, general division?
And I have to look at the docket, Your Honor, but my memory is at the time he filed his complaint in the general division, he had a pleading in DR court asking that the court vacate or overturn he already got the order for the vacate the rearages. I think he was trying to file a motion, or he had filed a motion to obtain the child support that had already been previously paid. And then Mr. Lopp goes on to cite 3119.964B that says that statute clearly gives this court or the general division a remedy. It does not, Your Honor. If you read the statute B, it says that if the court grants relief from a child support order and the arrearages are owed, the court may issue an order canceling that arrearages. And that's exactly what happened here. The DR court canceled the arrearages, but that's not what Mr. Lopp's client is seeking. He's not seeking just a cancellation of arrearages. He is seeking a refund of all previously court order lawfully imposed child support. There's nothing in the statute that allows him to recover that. And in fact, I cite case law after case law that says the statute is only used prospectively and to stop future child support and to cancel arrearages. You cannot go after the mother for child support that was already previously paid. One, because there was a court order, so it was lawful. Two, he was considered the father during all those payments. So at no point, and there's no statute, and Mr. Lepp has failed to cite any in his briefs that, or any case law that says once child support is paid per a valid court order, that if it comes out that he's not the father, that somehow he can get that money back. There is no such mechanism under Ohio law. All that allows.
So are you saying that, counsel, are you saying in domestic relations court, he cannot receive a judgment against the mother for her, allegedly, because it's a motion for judgment on the pleadings, essentially for her bad acts?
If
there's
he, as Mr. Lepp stated, on July 15th, this gentleman did file a 60B to vacate the underlying court order. If the court, the DR court grants that motion, there is no valid child support order, then in that case, if whatever monies he paid, there may be defenses such as that's a gift or something else, but yes, he could theoretically get that money back once the DR's order is vacated under a 60B, which again, he is seeking and that he has filed. So again, this gentleman goes to DR, doesn't like all the rulings, then he comes to general division, and now he's going back to DR. Again, he can't do that. He has to pick one lane, and he picked the DR court first. And as Judge McCarty ruled in her decision, he's trying to have it both ways. And if you read his original complaint in the general division, Your Honor, he's saying, what are my damages? He says his damages is the child support I had already paid. So he is seeking a refund of what? Child support. Which jurisdiction, which court deals with the jurisdiction of child support? In Summit County, it's exclusively the DR court. There is no authority whatsoever that a general division or juvenile division or probate division can address matters related to child support or even post-decree matters involving child support or paternity. Those are all exclusively, as stated by the General Assembly, it's all exclusively within the jurisdiction of the DR court. So he is seeking damages for child support. He's seeking to vacate the order of child support. He's seeking to enforce the non-paternity, which again, a paternity issue is a DR. So everything belongs in DR court. Whatever remedies is available to Mr. Lepp's client is all available in DR court, regardless if you call it a fraud or a modification or a vacation of the child support arrearages or whatever. It's all DR matters. And again, if he didn't think the DR court had jurisdiction, why would he go to DR court and ask to vacate child support arrearages and already previously owed? It doesn't, I mean, he himself believes that DR court has jurisdiction. So again, Your Honor, for the reasons I stated out in my brief, I have been unable to find a single case, and Mr. Lepp again has not cited a single case that any of the facts like this would allow general division to hear his complaint of fraud when there's already a previous pending motion in DR court and all the matters are exclusively within the jurisdiction of the Summit County Domestic Relations Court. So if there's no other further questions, I stand on my brief.
Would he be able to, he would not be able to get punitives awarded through the domestic relations court, though. He is seeking punitives in his complaint.
I don't know that to be true, Your Honor. If he's alleged fraud, I think the DR court can and successfully proves fraud to the DR court. I think the DR court can give him whatever damages it feels is appropriate under its jurisdiction.
Thank you.
So I wouldn't concede that right off the bat.
Okay, thank you.
Thank you, Your Honor.
Thank you, counsel. Mr. Lepp, you have your full 5 minutes.
I probably only need just a few seconds here. I just want to make sure that this court is very aware of RC 3119-964B. It states very clearly, nothing in this section limits any actions that may be taken by the person or male minor granted relief under this section to recover support paid under the child support order from which relief was granted. Any actions. It's not saying specifically that those actions have to be the domestic relations court. My client cannot be made whole in the domestic relations court. I wish Mr. Agarwal were correct in his belief that punitive damages were available there. They are not. If they were, then my client could be made whole there. He cannot be made whole there. Thank you. That's all I have.
Do you concede the assignment of error number 2 since it was not raised at the trial court level?
I'm not conceding the assignment of error. I concede the fact that it was not raised previously. That is very true.
All right.
Gentlemen, thank you
further
both.
questions. Thank you.
I'm sorry, Judge Tito.
No, I thought you might have thought I had a follow-up question, but I don't. I just want to let you know I'm done.
Okay. Thank you both, counsel, for your presentations today and for your briefs. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Have a great day, guys.